Send Mohammed in with the motions for Nunley. Thank you. Bye. These are still failures to appear.
Okay.
No, that's me. I didn't even see you when you grabbed them. Yeah, the last time
Thank you.
Mr. Nunley's cases, are you ready? Do you want to grab files? Is there something else you need to do?
I'm gonna be requesting an adjournment.
Uh, let's, Mr. Nunley, do you want to pull your clients out while we do this? Do you want them present in the court? Well, you know what I mean, present. Do you want them in this main session while we call these cases?
Well, I mean, we can talk about the adjournment. I think I've already spoken to them, and I was aware
Okay.
that Mr. McConnell was going to be requesting adjournment. So I told them that, you know, if we're moving forward with the motions, we'd pull them out so that, you know, they'd all be here, but I don't think they need to be here for this part.
Well, then let me start with Mr. Chapman. This is 241124 SD. This is state of Michigan versus Anthony Chapman. May I have your names to your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people.
And Royce Nunley appearing on behalf of Mr. Chapman.
And Mr. Nunley and Mr. Mohammed, did you discuss this need for an adjournment before the court called the case?
Mr. Mohammed
It's
did
very
tell me
brief.
that he was going to be requesting an adjournment. Yeah, so we did discuss it.
Okay.
Yeah, it was a very brief discussion. I informed defense counsel that I wasn't present last week, and I actually am not sure if the motions were sent to the APA that was covering last week on Wednesday, but I received them on Wednesday. I was not working Wednesday or Thursday, and so respectfully, I'm just requesting a 1-week adjournment to be able to go through. There was like 6 of them filed, to go through all the motions and review them to have a proper response.
And I would oppose the adjournment. I mean, simply, the nature of the motions, right? Speedy trial motions. I think Mr. Chapman, who we're talking about now, there was a delay of more than 19 months. And I think that the other 2 that I had filed was 2.5 years and more than 2 years with that one. So, you know, as they say, justice delayed is justice denied. These poor people have been, you know, waiting with bated breath to see what their future was going to look like for the last couple of years. So, you know, we're here, we're ready, we filed our motion, we're ready to move forward. That's really all I can say about it.
And Judge, I would just say, you know, I think I don't want to speculate, but I'm pretty sure that the rules of evidence require at least 7 days notice. And I haven't been technically properly served because I wasn't working, I don't think. And I don't know if that's appropriate to say, but if defense counsel wasn't present last week, then he would have known that I wasn't here and I had an automatic.
I'm sorry. The case was scheduled for last week, but it was adjourned well before that. Mr. Nunley, have you appeared in this case since this court set the date back on January 29th?
We appeared, and then I indicated to the court that we were going to be filing motions on it. And I think it was originally in front of Judge Patton, and then the court reached out to my office and said that it was going to be moved to Your Honor's docket, and then moved it because I think it was originally scheduled in February 26th was when it was originally scheduled. So they moved it to your docket for today. So
the answer to my question is no, you have not appeared since January 29th.
That's correct.
And that these motions, the 3 of them, which I'm guessing the arguments would be similar, were all sent to Mr. Mohammed's email?
They were sent to Mr. Mohammed's email on Wednesday, the same day that they were served to Your Honor's chambers. He was copied on that email.
And Mr. Mohammed, is it your assertion to this court that in your absence, your emails are not reviewed?
Judge, it's my assertion that on the day that defense counsel sent me that email, he would have received an automatic response on that same day telling him that I'm out of the office and that I'm not present. And also, I was not present last week.
The case didn't go last week, and Mr. Nunley is shaking his head that he didn't get an automatic response. Is that what you're indicating, Mr. Nunley?
I did not know.
And just I can go pull up my emails and provide it to the court.
I can pull it up right now. I'm right in here in front of it. Let's see, sent. Mohammed. Yeah, it was sent on March 4th. I never received any sort of automated response.
Judge, is it okay if I go pull my computer and review the emails?
Absolutely.
Because I was not the person who sent the email, I wouldn't be able to see what he exactly. But what I can show is a test email I did on February 24th, which says, "Hello, I hope this email finds you well. This is an automatic reply. I am out of the office and away from my email and phone until February 28th. So that would have been the email that defense counsel would have received because
Your Honor,
he indicated that he sent that email on February 26th, and that this automatic response was activated up until the date of the 28th.
Your
I
Honor,
just read that.
we could put this,
Mr. Nunley,
yeah, we could put this to bed. I mean, if I can just share my screen real quick, I'll show you the email thread. I mean, it's got the entire thread there. You'll see what I got and what I didn't.
Mr. Nunley, I don't know that that's necessary. We appeared here on January the 29th, and this court had, and has received 3 motions, all of the same similar argument. And the court did receive the motions on the 26th. I had Mary Ann confirm that Mr. Mohammed was included in that email string, and respectfully, Mr. Mohammed, even if your automatic reply is on, as a courtesy, I would expect another attorney, if they knew that you were out of the office for an extended period of time, to grant your motions or your request for this court to adjourn these motions 1 more week. But your indication to the court on the record is that you were back on the office on Friday. And if you then see motions from Mr. Nunley, the court expect to see your request to Mr. Nunley then, or Monday or Tuesday, requesting that these matters be adjourned over for 1 week so that.
Your Honor, I did respond to the court and defense counsel. The court was in this email where I asked for an adjournment. It was in the email, Judge.
Yesterday at
With the
4:52 PM is when he
I'm sorry,
sent
Mr. Nunley, I couldn't hear you.
I'm sorry, he sent his email requesting the adjournment yesterday at 4:52 PM.
Yeah, that's Mr. Mohammed, that's not a timely request to adjourn a motion. This court closes its doors to the public at 3:30, and although I was here after 4 o'clock, my secretary is not and would have not seen that yesterday, and this morning when I came in, it was not raised with me. That being the case, the court's going to deny your request to adjourn the motions. So that being said,
I'll respectfully request 15 to 20 minutes to review the motions, and I can be response to all 3 cases today.
absolutely. Mr. Nunley, I'm going to pass this matter for, let's say, 15 minutes. We'll be back on the record at 11, let's say 11:50.
Okay. I'll
Thank
see
you.
Thank you.
Did you finish with Mr. Fish?
No.
Okay. Mr. Mohammed, the court is ready to proceed on these motions, and there is an exam case that is in this courtroom.
All right. Yes, Judge, I'm ready. I'm not going to be responding to the motion, Your Honor, but I'd like to cite to Michigan Court Rule 2.119 that states that a response to a motion must be filed within 14 days after a motion is served, unless the court orders otherwise. The rule in this case is designed to ensure that both parties have a fair amount of time to prepare their arguments and present their case to the court. And respectfully, Your Honor, I was not working last week on Wednesday nor Thursday. The court is aware of that because there was another prosecutor covering the hearing, and defense would have been aware of that because he would have received my automatic response. So respectfully, Your Honor, I do think it's in the interest of all parties in this case that the court respectfully give us a 1-week adjournment so that I can have a proper response to these cases. And to read, I haven't read them.
Mr. Mohammed, before Mr. Nunley responds, I will say for the second time that these cases did not go last week. When the parties appeared in this court on January the 29th, the court ordered that the cases be on Judge Patton's docket on February 26th. That same day, the cases were reset to today. So that there was no last week. And the court rule that you're reading is not the accurate one. Mr. Nunley properly filed the motion 7 days before they were noticed to be heard. That being the case, Mr. Nunley, what was it that you wanted to say, sir?
I was just going to say that he's citing the wrong court rule. I don't know if he's citing the rule for summary disposition motions, but I was just going to point out what the court already did, that there's not 14 days required for a response.
Okay, then I may be, that's what I could pull up in short amount of time, Your Honor. Respectfully, I would request the court to disregard that citation then. But Judge, the 7 days would be 7 business days, and the prosecutor that was working last Wednesday, which the court would have been aware of because the prosecutor was present, did not receive it. I did not receive it. Even though he was sent to my email, I did not have it. I wasn't working. So I don't think the 7 business days would apply. I think it would be technically 5, but also, Your Honor, I think the court could take notice that I cover 3 other courtrooms. And so I'm returning on Friday, but I'm returning for 4 different courtrooms, and I have multiple emails. And so I would request respectfully to have 7 business days to review those emails that I received while I was gone. And if I had received it last week on Friday, it would not be 7 business days. We would only be on day number 4 now. And I did respectfully request defense last week not last week, but yesterday, to allow me to get an adjournment in this case. And so worst case thing that happens is the court dismisses the case, and then we will just reissue the case and start all over it. So if the court really intends on us restarting all these matters, we will be doing that. But I think in the interest of all parties, we can just adjourn this for 1 week respectfully.
Can I jump in real quick, Judge?
Mr. Mohammed, is there anything else, sir?
There's nothing more that I can add, Your Honor.
Mr. Nunley?
So the court rule doesn't require 7 business days. It just requires 7 days, right? And further, there's no exception in the court rule if somebody's out of the office. I'm out of the office once in a while. I wish I was out a little bit more often.
But it requires notice, serving notice. And if somebody's not working, you're not providing notice. If as the court, it was scheduled for last week, but it didn't go. Why it didn't go, I'm not really sure.
For the 3rd time, when this court scheduled it on January the 29th, I noticed it for Judge Patton's docket for February the 26th. On that same day, January 29, 2025, Judge Patton's secretary reset the cases for today. They never went on the 26th of February as previously indicated. There is no requirement that these cases be set, the response time or the filing time, the notice time be 7 business days. It would be 7 days unless day 7 fell on a weekend or a holiday. And if that is in fact what happened, they would be adjourned to the next business day. And when you talk about the interests of justice, it is not the court's care or concern if the prosecutor decides to appeal a decision made by this court or refile a case. But when I look at 241124 SD, and we are now 1 year, 10 months, and 20 days from the arrest, that is not timely. When we look at 241127, we are 2 years, 3 months, and 14 days from the arrest. When we look at 241128 SD, we are 2 years, 9 months, and 4 days from the arrest. I think that Mr. Chapman, Mr. Edens, and Ms. Lawrence have a right to have their cases heard in a reasonable amount of time. I went through Mr. Nunley's motions.
Okay.
And Judge,
The delay in time, excuse me, the delay in time between the time that the lab reports were sent back to law enforcement and these cases were issued is unacceptable. Whether the court adjourned it for a week or 6 weeks, it would not change the facts of the case that these people are arrested and we are a year or more before charges are issued. We are a year and 10 months to get here, or we are more than 2 years to get here. So unless you think that something magical would happen between today and next week, or the next time the court will be on criminal docket, which will be April 16th, the facts of the case do not get better with age. That being said,
Respectfully, Judge, speedy trial issues arise after the charges have been issued by the prosecutors, not at the time of the arrest date. So those dates, while they are important, it's not when speedy trial issues arise. They arise at the time of the issuance of the case, when a judge signs the case and the defendant then becomes arraigned and therefore after. But the defendant was not in custody. So speedy trial does not even apply in these cases. I have to go through each case, but just preliminarily speaking, speedy trials arise after the prosecutor's office issues charges, and that's when speedy trial issue arises, not at the time of the arrest date. So isn't even applicable.
Yeah. Yeah. Can I jump in?
I called your name, sir. Yes.
Yeah, I was trying to jump in. Mr. Mohammed cut me off. I would ask him to respect the decorum of the court and to allow me to finish my argument this time. So first and foremost, he can say that he's going to recharge the files all he wants, but a speedy trial violation requires that the court, if the court is going to dismiss the matter with prejudice. So if the court is inclined to grant my motions, then the motions have to be dismissed with prejudice. Second, the prosecutor's assertion that the right to a speedy trial doesn't start to run until the prosecutor issues charges is just false. It's blatantly false. I can read you all of the cases that I've cited in my brief that say that they run from formal indictment or arrest. I've defined clearly how the court defines an arrest in my brief also. I can go through each case and I can tell you how each of these three individuals were indeed arrested. So Mr. Mohammed's blanket assertion that it doesn't run from arrest, that it just runs from whenever the prosecutor decides to file charges. I mean, common sense would cut against that, as well as the case law, right? So a person can be arrested in 1974, and then the prosecution can get around to filing charges in 2025, and that's okay. That's obviously not the answer, right? And the cases that I cite in my brief all clearly state that the time to judge a speedy trial runs from either formal indictment or arrest. All three of these individuals have been arrested. That's when the clock starts ticking. So if the court has any further questions, I'm happy to answer them. I would just state that the prosecution's arguments that he's made today are just wrong. He cited the wrong case or the wrong court rule for his time to respond to a motion. He just blanketly asserted that he gets 7 business days to respond to a motion, which is just false. I would love to hear the authority upon which he's relying instead of just saying things. And he just says, oh, well, the time to judge a speedy trial runs from arrest. Of course, without telling the court which authority he's relying on. So these blanket assertions, just saying things without any court rule, case law, or anything to back it up, when most of us, when it's pretty generally accepted that what the court rule says about your filing motions and how long you have to respond, I think that those assertions speak for themselves, and that's all I have.
Anything else, Mr. Nunley?
Judge, I would like to respond. I don't just blurt things out. I had very limited time to have a response, Judge. You gave me 15 minutes, but as soon as I came out, I had to handle 11 tickets. So my time limit is very short. And respectfully, that's why I asked for a 1-week adjournment. I'm not asking to adjourn this months out. It's just 1 week. This is the first hearing. And again, I'm restating my position that I believe speedy trials arise at the time of formal charges, not at the time of the arrest. I believe there is case law that supports that, and I would like an opportunity to present that. I understand the court will not issue me a 1-week adjournment. So then I would respectfully request that if the court's gonna dismiss this case, that they not do it with prejudice, so that when we do reissue, if we reissue, we can make our proper arguments. Because I don't believe I've had a fair and opportunity to do that, Your Honor, respectfully.
And I would just, again, reiterate that I don't believe that the court has discretion. If the court is going to dismiss, it has to be a dismissal with prejudice.
And respectfully, I'd reiterate to the court that the court can make that decision. Defense counsel doesn't make decisions for the court.
We can iterate and reiterate until the cows come home. The other exam, the 11:30 exam, is here in the courtroom. Mr. Mohammed, the court sympathizes with you. I was also out of the office on Monday, came in on Tuesday to a stack of motions from Mr. Nunley that the court then had to stop what it was doing to make sure that the cases were reviewed, that I checked the deadlines, that Mr. Nunley asserted in his motions to be true and accurate, to read the authority cited, and to do other research to make sure that the court would proceed properly. For the prosecution to send an email to the courthouse at 4:52, the day before the motions are heard, when you acknowledged on the record that you were back in the office on Friday, is not acceptable. The court takes issue that Mr. Nunley was included in the email chain where you were asking for the request, but he didn't respond. At 4:52, I wouldn't expect a response from him, but the court has read the motions. In 241125, State of Michigan versus Anthony Chapman, the defense motion to dismiss with prejudice is granted. In
Well, Judge,
241127 SD, State of Michigan versus Ricky Ettins, same outcome. Case is dismissed with prejudice. 241128 SD, State of Michigan versus Maryland Lawrence, case is dismissed with prejudice. The defense motions are granted. Mr. Mr. Mohammed, you have an absolute right to disagree with this court's ruling. Your office's options are to file a motion to appeal or take some other action. Unless there's anything else in this case, this court is ready to move on to its 11:30 docket.
Well, Judge, the court never responded to what I stated in regards to speedy trials apply at when formal charges are brought, not at the time of the arrest. What's the court's position on that?
My court's position is that Mr. Nunley's motion addresses that. The authority cited his motions address that.
Understood. Thank you.
Thank you.
Thank you, Your Honor.
My apologies, Ms. Goki and Ms. Peoples. The court needs to take a 15-minute recess. I will be back out here at 12:30. To the other people who are waiting for the exams, my apologies. I'll be right back.
Ricky, Marilyn, Anthony, I'm going to move you back into my waiting room briefly, just so I can kind of debrief you guys, and then you'll be free to go, okay?
Okay, thank you.